second installment of the Monday Morning Message. So this week we're going to cover pages 9 through 15 of your text. So I'm going to go ahead and share my screen with you and we'll get started. So on page 9, we kind of left off with, we talked about PHI, protected health information, which is confidential information, right, that we are going to help to maintain a right to that confidentiality for the patient. But there are exceptions. There are exceptions that the patient can actually dictate to us what those exceptions are in terms of having a signed consent that says that we can release information to entities that the patient has determined is appropriate, such as a spouse. You know, husband and wife that says, hey, I give my authorization on the consent to allow my wife to have access to my medical records. There are different things that can be in a consent, things like alternative means of communication. So you can request that a provider, send your blood work results only through email or only through telephone, only to one particular number, or not to leave messages. Those are things that patients can actually dictate in their consent. So today we're going to kind of focus on the things that do not require a consent. And so this particular page 9, it starts out with the other PHI releases not requiring permission, meaning permission from the patient or the subject in the matter. So when we talk about this, if you notice, it's got several bullet points here, and we'll touch on a few of these things. Reporting certain communicable diseases. The reason why we do not have to have a release for something like, certain types of infections, HIV infections, hepatitis B, the state automatically gets those numbers typically from the laboratory. So when the laboratory has a positive HIV result, that information is sent to the state health department. The reason for this is not necessarily so that we know who has what. It's so that we can look, it's so that epidemiologists can look at, are we seeing increased cases of something someplace? When we look at something like the COVID pandemic, how do we know where hot spots are? It's because we gather information. So this is one of those ways of gathering that type of information so that we can make sure that we're not having some outbreak of something like hepatitis A or hepatitis B or HIV or something that needs resources sent to that particular area to try to mitigate the damage from having one of those communicable diseases. Okay. Things like suspected child abuse. This one's a very tough one. Child abuse, elder abuse, more common than we probably like to admit. Very difficult sometimes to actually, try to pinpoint these types of things. But when we suspect, after a provider has really gone through some due diligence to determine whether they believe that there is some form of abuse, whether it's child abuse or elder abuse, if they believe that that's happening, then we have an obligation to actually report that to authorities so that we can get, law enforcement agencies involved. Now, they may or may not determine that there is some form of abuse, but this is typically done, it's not done willy-nilly. It's usually done after some very thorough investigation by the healthcare providers in order to kind of make that claim that, yes, we believe there is some potential abuse here. So that's one we do not need the patient to, say, oh, it's okay to call the authorities. That we don't need that. Things like gunshot wounds and stabbings, those are automatically reported to authorities. A crime was committed against somebody. We have a duty to inform the authorities that this has happened and then allow the authorities to do investigatory work so that they can determine whether somebody needs to be charged, arrested, that type of thing. So those are, we have to report that. Responding to court orders, things like subpoenas. We unfortunately don't get to say no. When we get subpoenaed and we have to provide records to a court of law, then we have to do that. Reporting suspicious deaths, that's a good one. Again, if there's something that may have the potential that law enforcement agencies need to be involved, then those things that we have to report those things. Okay. Um, the warning those in the community when a patient has made a credible threat to harm someone. Again, this is one of those things that we take very seriously. It doesn't happen very often that we do have to report on this, but I think it just makes total sense, right? If somebody has threatened to do harm in the community of some sort, as healthcare providers, we have an obligation to actually protect the community as a whole, not only just the patient. Okay. Um, Things like the family and friends. This is an interesting one. Because I think sometimes a lot of lay people that aren't in healthcare, think that it should be okay to tell somebody's close personal friend that there's something going on with them, or their clergy member, their pastor or something. Again, without obtaining a written authorization from the patient, we have to be very careful about how much, if any, information we can give to people. We have to protect that patient's privacy, their PHI. We have to be very careful about giving somebody too much information that you as a patient have not authorized us to do so. Okay. HIPAA and minors is another important one. So in looking at that first statement, it says HIPAA primarily relies on state laws to define minors and to specify when minors must give permission to providers to release their PHI. I've gone ahead and provided you with a little handout, and I'm going to share that with you as well. That pertains just to California, and that will be found in your Canvas course shell. Under additional resources, there is a handout right here, the Adolescent Confidentiality Toolkit for the state of California. And what that does is it kind of defines what those things are. So here is where I was able to get that from, but this is already there in a PDF for you in your additional resources. So it defines what rights a minor has in the state of California. For all intent and purpose, a minor in the state of California is basically defined as somebody who is 12 years old, and then they have certain rights that are given to them by the state. Okay, so if you look at something like outpatient mental services, for instance, this one. Does a minor who is 12 years of age or older may consent to mental health treatment or counseling on an outpatient basis? Okay, and it says there's got to be two qualifying conditions. The minor, in the opinion of the attending professional person, is mature enough to participate in these services, and the minor would present a danger of serious physical or mental harm to themselves or to others, or if the victim is, or the alleged victim may be a victim of incest or child abuse. Okay, so they can consent at 12 years old, which means that information that's shared with a mental health provider now becomes confidential between that 12-year-old or older minor. So when you go through some of these and take a look at them, familiarize yourself with them. In particular, if you are going to be working in healthcare and doing one-on-one patient care, it really is important for you to understand which one of these might apply to you. Okay, so another good one might be this one: AIDS and HIV testing and treatment. A minor 12 and older is competent to give written consent for an HIV test. Okay, and then it says the confidentiality, which is kind of cool, right? So it says the healthcare provider is not permitted to inform a parent or legal guardian without a minor's consent. The provider can only share the minor's medical records with the signed consent of the minor. So in the state of California, at 12 years old, a minor, a 12-year-old child could go to a doctor and request an HIV test. At that point, if they're consenting to this test, then they have a right to confidentiality, and they would have to, in order to provide parents with something, with a test result, would have to sign a consent saying that it is okay for us to share. Now, for some people, and I don't want to get too much into the weeds on this one because there can be some debate. I know there's debate on whether this is whether parents agree with this philosophy or not, that the 12-year-old has the right. But here's the thing that I typically say is that a child, just like anybody, is not somebody's property, regardless of whether you're the parent or not. Certain laws have been enacted, and those laws are the law of the land, and we have to follow those. So as a healthcare provider, just because a parent says, hey, I need to know this, I want to know this, unless that child has provided a consent allowing us to share that information, we can't do it. And as part of protecting my ability to earn an income and to continue to work in this profession, I have to follow the law. Regardless of what my personal feeling is about that, I have to follow the law. If I don't, I could be fined or imprisoned if I were to violate the law purposefully. So this can create some ethical dilemmas or some moral dilemmas for people. So these are things that you have to consider when you work in this profession. When you sign up and say, I want to work in healthcare, then you're also agreeing that I'm going to follow the rules, the regulations, and the laws that pertain to healthcare, and this is one of those. Okay. So take a look at that, giving you that handout there. HIPAA and domestic abuse, same thing. Dealing with, I like this paragraph that says dealing with domestic abuse is complex, and it is. Consult your compliance or privacy officer. Whenever you have questions about anything, you should consult whoever your HIPAA privacy officer is. Consult your attending physician or your attending nurse or whoever it is that might be your supervisor to review what steps are needed or to be taken with a suspected abuse case. Okay, and then become familiar with what your state laws are as far as reporting and that type of thing is concerned. All right. Let's see here, HIPAA authorization. So it says covered entities are permitted to use and release PHI for treatment. Then this is called TPO, treatment, payment, and healthcare operations or other healthcare operations. So we can release information for things such as treatment, payments like to insurance companies, and for other healthcare operations that allow us to run a business. Okay, so all other things typically require a patient's consent. So when we're talking about giving information to family members, giving information to friends, the minor consent issues, those things typically, other insurance companies like life insurance companies sometimes will ask you as a patient for records about your health history. We can't give those to a life insurance company without your written authorization to do that. Okay. Sometimes from doctor to doctor. Certain things in relationship to treatment are a foregone conclusion. We can give certain things to other healthcare providers in order to get you treated appropriately. However, some things need to have a signed written consent. So a good example of that might be for me in previous family practice work, if we referred a patient, let's say somebody came in for a knee problem, and we did some examination, maybe we took an x-ray, maybe we even did some blood work, maybe we're looking for arthritis. So let's say we did an x-ray, some blood work, and a couple of visits with this patient. And the family doctor says, you know what, I don't really know what's going on. I'd like to refer you to a specialist. Typically, in order to have continuity of care for treatment purposes, we'll send that specialist a copy of the notes of the visits about your knee, the blood work that we did, and the x-ray results. And that's it. That's what we're going to send them. Now, if that referring physician says, hey, I would like to have all of their chart, I'd like to see what their whole health history is, then we've got to have the patient sign a consent to release the rest of that information, because we gave them everything that pertained to the knee that we have done, but we didn't give them anything else. Now they want to know about all the rest of your history. we're going to have to get you to sign a consent so that we can release that additional information to that referring physician. So that's a good example of how that might work, okay? And, excuse me. And then I kind of like this case scenario. Oh, and I like this one too, this note. Let's kind of cover that note. It says providers cannot refuse to treat patients who won't sign authorization forms. This is true. Can't do that. So let's say that maybe we were requesting an authorization to release some information to a referred physician, and you refuse to sign that. We can't not treat you. However, it may limit the patient's ability to get treatment, in particular from that referred physician that we sent you to. They may say, well, there's nothing more I can do until I can see the rest of the chart and see what the patient's history is. There's nothing more that I can do. So when patients make a decision where they don't want to sign a consent, oftentimes that can actually delay their care. And there's not much that we can do about that other than try to explain to the patient that this might happen if we don't get that information sent off to somebody else or don't get that to another entity. So that happens every once in a while, but we can't refuse to see them or to treat them just because they refuse to sign that consent. But it could harm that patient later on down the road, and that's out of our control. The patient chose not to sign the consent. Okay, so this scenario is actually pretty good. It says you arrive home at the end of a long day and call your mother. And this happens. During your conversation, you describe a patient with particularly bad burns over 50% of their body. You're very careful not to mention the patient's name or even any other real identifying information. Okay. It says the evening news includes a full report of the fire that destroyed a house across town. The news report identifies the individual who was trapped until a firefighter rescued him. It says, after viewing the news report, you wonder whether you said too much. Did you? It might be possible. It says you were correct not to mention the patient's name, but if you share too many details about the patient, the person with whom you're speaking may be able to identify that patient. In this case, if the fire was the only one in town that day and your mother now knows the identity of that patient, then you violated HIPAA and you should report that to your privacy officer. Now, it doesn't necessarily mean, number one, that you did it on purpose, that you meant to do it. Number two, that there may be any real disciplinary action taken unless it was found that you've really violated this patient's privacy, and that you might have done it with some intent to harm that patient. Obviously, I think you all know you're going to be in trouble for that. But from an internal perspective, this may be those types of things where it might be a verbal warning. It might be some write-up into your personnel file that conversations were had, that this was a violation of HIPAA and that it can't happen again, or you could lose your job, be terminated, whatever the case is, whatever your managers decide to do. But that definitely could end up being a HIPAA violation, and you didn't even really know it. We fairly commonly, unfortunately, have these incidental violations that we don't necessarily think of. So again, this is one of those examples, like I mentioned last week, about really being very careful about your choice of words, about who you're speaking to, how much information you're giving, and remembering that, how do I want my information to be handled? How would I want somebody to talk about my care if they weren't talking to me about that? How would I want that information to be handled, including going home and speaking to somebody that you live with, or your mother or your husband or your wife or your significant other, whatever the case is. You have to be very careful about talking about things that you saw during the day. Most of us try not to do that, and oftentimes it does take you to really force yourself to not discuss in any great detail the things that you saw in the office or at the hospital today. Even though we like to vent and we like to talk about what our day looked like, it needs to stay in very, very general terms with as little information about a patient as possible. So anyway, that's where we're going to leave it off today. Next week, we'll pick it up with the do's and don'ts, and we'll talk about some of these issues. So again, look at your Canvas, peruse that PDF on minors in California and what that looks like and what your responsibilities look like as far as that's concerned. And I look forward to seeing you again next week for another Monday Morning Message.